Jeffries.
Mr. Whitaker, thank you for your presence here today. This hearing is important because there are many Americans throughout the country who are confused. I'm confused. I really am. We're all trying to figure out, who are you, where did you come from, and how the heck did you become the head of the Department of Justice? So hopefully you can help me work through this confusion.
All right, well, Congressman,
Mr. Whitaker, that was a statement, not a question.
Okay.
I assume you know the difference. The investigation into possible Trump-Russia collusion in the 2016 election has resulted in 37 indictments. Is that correct?
I believe that number is correct, but most of those folks were Russian citizens.
34 individuals have been indicted, true?
While I haven't counted those as I prepared for my hearing preparation, I believe those are consistent with the numbers that as I know them.
3 corporate entities have been indicted, correct?
I believe so, correct.
The investigation has identified 199 different criminal acts, true?
I haven't counted every indictment, but that sounds consistent with what I understand.
There have been 7 guilty pleas, correct?
Yes, there have been 7 guilty pleas.
4 people have already been sentenced to prison, true?
I believe so, but I do not have this information in front of me. So to the extent that, I disagree with you, it's because these are facts.
Understood, thank you. Trump's best friend, Roger Stone, was recently indicted for lying to Congress in connection with his possible involvement with WikiLeaks and Russian interference with the 2016 election, correct?
Yes, and I mentioned Mr. Stone's indictment and arrest.
Trump's campaign chairman, Paul Manafort, pled guilty to conspiracy to defraud the United States, true?
Mr. Manafort did plead guilty, yes.
Trump's deputy campaign manager, Rick Gates, has pled guilty to lying to the FBI, correct?
While I don't have the indictment in front of me, I have no reason to disagree with you.
Trump's former national security advisor, Michael Flynn, has pled guilty to lying to the FBI, correct?
That is a true fact, yes.
Trump's longtime personal attorney and consigliere, Michael Cohen, pled guilty to lying to Congress about the Trump real estate organization's Moscow project. Is that true?
I believe that was one of the bases for his plea agreement. There were several other reasons that Mr. Cohen pled guilty.
Trump's campaign foreign policy advisor, George Papadopoulos, has pled guilty to lying to federal investigators about his contacts with Russian agents during the 2016 campaign, true?
While I'm sure there are many who would disagree with that title that you put on Mr. Papadopoulos, it is true that he has pled guilty, yes.
So despite all of the evidence of criminal wrongdoing that has been uncovered, do you still believe that the Mueller investigation is a lynch mob?
Congressman, can you tell me specifically where I said that?
I'd be happy to. So in a tweet that you issued on August 6th of 2017, you made reference to a note to Trump's lawyer: do not cooperate with Mueller's lynch mob. You recall that?
I recall that I said that I retweeted an article that was titled that. I did not necessarily agree with that position, but my point was that it was an interesting read for those that want to understand the situation.
Okay, reclaiming my time. Manafort, Gates, Flynn, Cohen, Papadopoulos, and Stone are all in deep trouble. One by one, all of the president's men are going down in flames. It's often said where there's smoke, there's fire. There's a lot of smoke emanating from 1600 Pennsylvania Avenue right now. Yet, you decided not to recuse yourself, is that right?
Congressman, the decision to recuse was my decision to make. I looked at all of the information. I consulted with many people that I've discussed today, and I determined that it was not necessary for me to recuse.
And Donald Trump considered the Sessions recusal to be a betrayal, is that right?
Congressman, I have no idea as I sit here today what the president believed about General Sessions' recusal.
Okay, so let's be clear. The investigation into Russia's attack on our democracy is not a witch hunt, it's not a fishing expedition, it's not a hoax, it's not a lynch mob, it's a national security imperative. The fact that people suggest otherwise comes dangerously close to providing aid and comfort to the enemy. In your final week, keep your hands off the Mueller investigation. I yield back.
I thank the gentleman. I now recognize the gentleman from Virginia, Mr. Klein.
Thank you, Mr. Chairman. Thank you, Mr. Acting Attorney General. I was hopeful that we would get into some oversight over the array of areas of the Department of Justice that are so critical and so important to addressing the problems that are facing my community: drugs, crime. All of these issues are of top concern to my constituents. And one of the most important things that I hear about when I get back to my district is, are you going to keep the government operating? Can you reach an agreement on immigration issues? So when we talk about immigration, I can ask you a couple of questions that would probably help get to an immigration agreement. The backlog of pending cases in immigration courts nationwide have been growing exponentially since 2008, from fewer than 200,000 cases in 2008 to more than 800,000. And Border Patrol is currently apprehending almost 50,000 aliens each month, a certain percentage of which ends up in that same pending case backlog. And in the face of this backlog, what steps is DOJ taking to ensure that its immigration judges can efficiently and effectively adjudicate cases and reduce this backlog of pending cases in a fair and efficient manner?
Thank you, Congressman. This is an important issue to the Department of Justice, and our immigration judges work hard every day to adjudicate those cases. But quite frankly, the number of immigration judges we have been overwhelmed by the number of asylum seekers. Over 80% and really over 90% of those that are encountered at the border and detained and arrested claim some form of asylum. Ultimately, that causes those folks to be put into the immigration court system, and then requires that a hearing be held by an immigration judge. And meanwhile, most of these folks, those 800,000 that are pending, are not part of the detained docket. They are part of the released docket. And those cases take longer, the ones that are not detained, the non-detained docket, and they have caused, since 2008, that number to go dramatically up. What we have done about that situation is General Sessions and I have issued Attorney General orders changing some of the specifics as to how those cases are adjudicated. And in addition, we have, together with the help of Congress, which you've authorized and funded more immigration judges, we have put a dramatic number of more judges, especially to the areas where it's needed, which is oftentimes at the border.
So you've also put in place an additional performance metric to gauge the performance of judges working to complete cases and reduce the backlog. Are those working? And you've gotten pushback from groups who are concerned that they amount to case quotas. And if they are working, are you aware of any organization in which productivity of its workers isn't assessed as one part of a multidimensional performance review?
Yes, in fact, government-wide, where there are administrative law judges similar to our immigration judges, there are typically performance metrics that are in place to not only evaluate their productivity, but also to budget and manage that workforce.
And what are you doing to ensure that continuances in immigration cases are not abused and are granted solely for good cause?
We issued an Attorney General order which set the standard, which had been different based on what the Immigration Appeals Court, which is an internal, the Board of Immigration Appeals, which is an internal DOJ body that the Attorney General sits over. We've passed rules and regulations and a new standard for issuing those continuances for good cause, as you mentioned.
All right, thank you. I yield back.
I thank the gentleman. I'll now yield to the gentleman from Rhode Island for the purpose of unanimous consent request.
Thank you, Mr. Chairman. I would ask unanimous consent that the following articles be placed in the record. The first is an article entitled Exclusive Trump Loyalist Matthew Whitaker was counseling the White House on investigating Clinton. A second article, Sessions replacement. Matthew Whitaker called Mueller's appointment ridiculous and a little fishy. Third article, all the time Robert Mueller's new boss railed against the Russia probe. Trump's pick to replace Jeff Sessions once said Mueller investigation risked becoming a witch hunt. And finally, an article entitled Trump's new acting attorney general once mused about defending Robert Mueller.
Without objection, these documents will be placed in the record. I now recognize the gentleman for 5 minutes.
Thank you, Mr. Chairman. Mr. Whitaker, I'm going to be really straight with you up front. I'm going to cut you off if you make long speeches. We have very limited time. You do not need to thank me for asking the question or compliment me that it's a good one. I'll assume they're all good questions and you're grateful. One, you were briefed by the special counsel. You've acknowledged that. Did you share that information with any members of your staff, the information you learned in that briefing from the special counsel or his team?
Congressman, as I previously testified, there was one other individual in that briefing with.
And who is that individual?
It is the U.S. Attorney from the Eastern District of California who I've brought on.
What is the name of the individual, Mr. Whitaker?
His name is Greg Scott.
So did you communicate any information you learned in those briefings to other members of your staff?
I don't believe so, no.
Do you know whether any information that you learned in those briefings were communicated to anyone at the White House?
As I mentioned previously, Congressman, we have kept a very close.
Mr. Whitaker, it's a yes or a no. Do you know whether it was communicated to anybody at the White House?
As I sit here today, I don't know whether it was communicated.
Did you put into place any restrictions or limitations or instructions to your staff not to share this information with anyone at the White House or the president's legal team?
Yes, together with the general standard that investigative information and materials are need to know and law enforcement.
Thank you, Mr. Whitaker. Did the president lash out at you after Michael Cohen's guilty plea for lying to Congress about a Trump organization project to build a tower in Moscow?
The president specifically tweeted that he had not lashed out.
I'm asking you, Mr. Whitaker, did the president lash out at you? I'm not asking you what he tweeted. I don't have a lot of confidence in the veracity of his tweets. I'm asking you under oath.
Congressman, that is based on an unsubstantiated.
Sir, answer the question, yes or no. Did the president lash out to you about Mr. Cohen's guilty plea?
No, he did not.
And did anyone from the White House or anyone on the president's behalf lash out at you?
No.
Mr. Whitaker, did the president lash out to you on or about December 8th, 2018 to discuss a case before the Southern District in New York where he was identified as individual one?
No, Congressman.
Did anyone on the president's behalf, either inside the White House or outside the White House, contact you to lash out or express dissatisfaction?
Did they contact me to lash out?
Yes. Did they reach out to you in some way to express dissatisfaction?
No.
Okay. Did you share the questions that Mr. Nadler forwarded to you prior to this hearing with anyone at the White House or the president's legal counsel?
Congressman, I did not.
So when you claimed earlier that you were going to invoke a privilege, you were invoking a privilege about questions the president hasn't even seen.
Congressman, to be clear, I'm not invoking any privilege.
Well, you said earlier that you, in your written testimony, that you would not answer questions about your conversations with the president. Did you not?
Yes, I did.
So you are not sitting here today saying the president has instructed you not to answer a question, correct?
I am not sitting here today saying that the president has instructed.
So then you're prepared to answer all these questions.
Congressman, I think I was pretty explicit in my opening statement.
So have you spoken to the president, Mr. Whitaker, about the Mueller investigation?
Congressman, as I have previously testified, I did not talk to the president about the Mueller investigation.
Have you ever spoken to the president or parts of his legal team about information that you've learned in your capacity as acting attorney general related to the Mueller investigation or any other criminal investigation involving the president?
Congressman, while I have specifically been saying that I'm not going to comment about my conversations with the president or his senior staff, I have also been very clear that the president has not instructed me to do anything.
So that wasn't my question. My question is, have you had conversations about what you learned? That's a yes or a no.
Congressman, I spend all day, every day talking.
Mr. Whitaker, my question is very specific. Have you spoken to the president or his legal team about what you've learned in the Mueller investigation or the related criminal investigations that may involve the president? Yes or no?
Congressman, as I specifically answered earlier to a question.
Mr. Whitaker, you're clearly not going to answer the question, so I'm going to move on. You know Professor John Barrett, correct? Well, anyway, this is a law school professor who tweeted that you told him in June of 2017 that you were flying out from Iowa to New York City to be on CNN regularly because you were hoping to be noticed as a Trump defender and through that to get a Trump judicial appointment back in Iowa. You then went on to describe the Mueller appointment of the special counsel as ridiculous and a little fishy, that Mueller investigating Trump's finances would be going too far, that there is no criminal obstruction of justice charge to be had against President Trump, that there was no collusion with the Russians and the Trump campaign, that any candidate would have taken the same meeting as Donald Trump Jr. with a Russian lawyer, and finally that a replacement for Sessions could reduce Mueller's budget so low that his investigation grinds to almost a halt. You said all those things, and they're all in print. And it answers Mr. Deutsch's question. The American people wonder just how is it that Mr. Whitaker becomes the acting Attorney General of the United States in violation of existing statutes? Was he put there for a particular purpose? That wasn't a question. It's a statement. I yield back.
I've observed that. The time of the gentleman has expired. Who's next? Mr. Reschenthaler. Mr. Reschenthaler is recognized.
Thank you, Mr. Chairman, and thank you, Mr. Whitaker, for being here today. I just want to quickly reference the letter that was sent to you from the chair on January 9th. In this letter, in the chairman's own words, it said that this committee was here to, quote unquote, to conduct oversight of the department. In this letter is also important other topics that were supposed to be discussed here today, like immigration, gun violence, the Violence Against Women's Act, Obamacare, national security, and that's not even the complete list. I know you read the letter. I was excited to be here. I thought these were critically important issues that affect the constituents of my district and millions of Americans. And frankly, a lot of these issues are life and death. So I'm really confused as I sit here today in this hearing with my Democrat colleagues focused solely on one topic, and that's the Mueller investigation. I really hope that my friends across the aisle would have used this opportunity for more bipartisanship and less showmanship. But clearly I was wrong. With that said, I want to get to some of the important topics that we were supposed to have focused on today. One of those is sanctuary cities. In my home state of Pennsylvania, the sanctuary city of Philadelphia has released at least 3 child molesters back onto the streets. And everyone knows the tragic story of 32-year-old Kate Steinle, who was murdered by an illegal immigrant who was convicted of 7 felonies and deported 5 times. Now, those child molesters in Philadelphia, the murder of Kate Steinle, they were all released because some city wanted to score cheap political points. And that's why I'm focused on ending sanctuary cities. Mr. Whitaker, what steps is the DOJ taking to end the dangerous practice of sanctuary cities?
Well, first of all, we're ending taxpayer-funded grants to sanctuary jurisdictions. The Attorney General Sessions announced new conditions for our burn JAG grants that will increase information sharing between federal, state, and local law enforcement to ensure public safety. I don't know if the congressman knows this, but one of the challenges we have is in a sanctuary jurisdiction, jails will release convicted criminals back into the community instead of informing Immigration and Customs Enforcement that the person is available to be picked up at the jail. It is an incredibly dangerous situation to make an ICE officer go into a community to try to arrest somebody that is here illegally and has been convicted of a crime, oftentimes crimes that, like you mentioned, and I cannot imagine a situation where a mayor or a city council or a county executive or otherwise would put law enforcement officers in harm's way. It is quite frankly bad policy, and we are going to work very hard to end it. And one of the ways we're ending it is by taking away the resources to those jurisdictions that have that policy.
Thank you, Mr. Whitaker. Mr. Whitaker, I have one more question regarding the opioid crisis. This crisis is striking our country hard, particularly southwestern Pennsylvania. Data from 2017 shows that it is more likely now that someone's going to die of a drug overdose than a car crash. My district has been hit really hard. In particular, Fayette County saw an 88% increase in overdose deaths from 2015 to 2017. What steps has the DOJ taken to address this shift? And do you think that a lot of the problems that we're seeing in these stats comes from a porous southern border?
To address your second question first, I do believe that most illegal opioids, like fentanyl, non-prescription illegal opioids, like fentanyl, heroin, and their derivatives are imported through our southern border. Some, not a majority, but some are also imported via direct mail, for example, and ordered off the dark net. I went through a list of things that the Department of Justice is doing to combat this opioid epidemic. I hope that this committee, while it's something I was prepared and wanted to talk about, and I appreciate the question, will look at other ways that we can put resources into the opioid crisis. 70,000 people, as you mentioned, have died of drug overdoses. A majority of those are from some form of opioids. And we also, quite frankly, and I mentioned my trip to China last August, we have to work together with the Chinese government to reduce the inflow of fentanyl. And we also have to, we have emergency scheduled right now, the fentanyl analogs, but we need an act of Congress, and I hope that we can get that to make that permanent, that these fentanyl derivatives and creative chemists that change the chemical makeup of fentanyl do not continue to try to evolve their drug to avoid our regulation.
Thank you, Mr. Whitaker. I yield back my time.
Thank you. Mr. Whitaker, did your watchdog organization ever receive contributions from foreign donors?
Mr. Chairman, point of order.
I'd ask you to stop the clock.
Now,
Gentleman will suspend. The gentleman will state his point of order.
my point of order, and I'm going to go back to this, and would, again, undoubtedly the majority does not care. But this is outside the scope of this hearing. This was not while he was employed here, and whether he outside had donors or not during the time he was not employed, making no connection either way is not inside the scope of this hearing. And that's not the call of this committee. Now, and look, I'm outgunned over here. I have no votes. This is not part of the call of the hearing. That's why, well, there's plenty of things to do. And Ms. Cicilline,
Will the gentleman yield?
Mr. Collins, if you want to sit down there with his lawyers, you can go sit down there, but you're not his lawyer.
Gentleman will suspend.
And neither are you,
Gentlemen,
Mr. Swalwell. And if you
gentlemen.
ask questions that are actually part of this instead of running for president down there, we could get this done.
You can sit down there, there's room.
Both gentlemen will suspend.
Mr. Chairman,
Gentleman has stated a point of order. The chair will rule the point of order is not well taken. The scope of people's questioning, we afford a wide latitude, and we don't even know where it's going at this point. The gentleman's point of order is not well taken. The gentleman will resume.
Appeal the ruling of the chair.
The gentleman appealed the ruling of the chair. The gentlelady moved to table. Move to table is not debatable. The clerk will call the roll on the motion to table.
Mr. Chairman.
Oh, let's call the roll. All in favor of tabling the resolution? I'm sorry. All in favor of tabling the appeal of the ruling of the chair will say aye. 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 Nay. Nay. The ayes have it. The appeal, the motion is tabled. Gentleman will continue.
Mr. Whitaker, did your organization have foreign contributions?
Just to be clear, are you
Yes
talking
or
about, what do you mean by my organization?
You led an organization called FACT. Did it receive foreign contributions while you were there?
I don't actually know the answer to that. I do not believe, as I sit here today, that it did, but our main donor was a group that was a U.S. entity.
Did you interview with Don McGahn in July 2017 to have the job that Ty Cobb would ultimately get?
I ultimately did not meet with Mr. McGahn, so I met with.
Did you talk with him on the phone?
We actually never did end up talking on the phone either.
Who did you meet with on his staff?
I talked to Annie Donaldson from his staff, who was his chief of staff at the time.
And when you talked to Mr. McGahn's chief of staff, did you express in that conversation your prior views about the Mueller investigation?
No, I did not.
Was it brought up by the chief of staff?
In fact, at the time, Congressman, everyone at the White House did not want to talk about the special counsel's investigation.
But you were interviewing for a job that would respond to the special counsel's investigation, is that right?
At the time, I was interviewing for the position that was ultimately occupied by Ty Cobb.
But I want to understand how you could interview for a job that would respond to the special counsel investigation, but you were not to talk at all about the special counsel investigation. How would they know?
Well, I said we
you would
didn't talk about it. They did not want to talk about the investigation because the folks were dealing with that investigation, and that's why they wanted to bring in someone that had been unrelated to the investigation and the campaign.
Did they talk to you about your prior opinions about the Mueller investigation?
No, we did not discuss it. We
Has there
discussed
been
about my background as a United States attorney and my legal practice.
Has there been discussion at the department about keeping the Mueller report from going to Congress?
No, we're continuing to follow the special counsel regulations as it relates to the report. And we haven't received the report.
Has there been a draft opinion about keeping it from going to Congress?
You know, Congressman, I'm not going to talk about the kind of ongoing investigation that is the special counsel. I will share with you that
Mr. Whitaker, did Donald Trump ask you if you would recuse before you became acting attorney general? If that question came up, did he ask you what you would do?
Congressman, I've already answered that question in my opening statement.
Do you believe Attorney General Sessions should have recused?
As I mentioned in my answers previously, the recusal decision.
No, do you believe, yes or no, that he should have recused?
I actually, as I sit here today, I do not have an opinion. I believe he determined it was the right decision for him to make, and so I agree that he made the right decision for him.
Have there been any discussions at the department about pardons for Paul Manafort, Roger Stone, Michael Flynn, or Michael Cohen?
Congressman, we have a very well-worn system
That the president doesn't follow, but have there been discussions about pardons for those individuals that you're aware of, yes or no?
Congressman, as I've been acting attorney general, I have not been involved in any discussions of any pardons, even and including the ones you're discussing.
You made a public statement last week that the investigation was nearly complete. Is that your characterization or is that Bob Mueller's characterization?
Congressman, that position that I mentioned last week in a press conference was my position as acting attorney general.
Would Bob Mueller, if sitting before us right now, agree with you?
You know, Congressman, Bob Mueller is going to finish his investigation when he wants to finish his investigation.
Is Mr. Mueller honest?
Congressman, I have been on the record about my respect for Bob Mueller and his ability to conduct this investigation.
Do you believe he's honest, yes or no?
I have no reason to believe he's not honest, so yes, I do believe he's honest.
Do you believe he's conflicted, yes or no?
Congressman, as I mentioned regarding recusals, you know, sort of the conflict analysis is for the individual lawyer to make once a matter is before them. And I'm sure that whether it's Bob Mueller, whether it's Rod Rosenstein,
But the president has
anybody
called
else
him
at the Department of
conflicted.
Justice,
The
they
president's
would do
called
it.
him conflicted and you oversee the investigation. Do you believe that Mr. Mueller's conflicted?
Congressman, as acting attorney general, I have followed regular order at the Department of Justice, and I have expected that the lawyers and the support staff and agents that work for me follow regular order. And as I sit here today, I don't have any reason to believe that.
So you don't believe you believe he's honest, you don't believe he's conflicted. Can you say right now, Mr. President, Bob Mueller is honest and not conflicted?
Congressman, I'm not a puppet to repeat what you're saying.
Are you able to say it, or do you not believe it?
I have answered your question as to what I believe about the special counsel. I stand by my prior statement.
Can you say it to the president, though?
Congressman, I am not here to be a puppet to repeat terms and words that you say that I should say.
Can you say that to the president?
Regular order.
Mr. Chair, he hasn't answered that question.
Sorry?
He has not answered the question if he would say that Mr. Mueller is honest.
The time of
not
the gentleman
conflicted
has
to the president.
expired. The witness may answer the question.
I don't have anything further to add. I think I've answered the Congressman's question.
That's a question for observers. The gentleman from North Dakota, Ms. Armstrong.
Mr. Whitaker, you've obviously been acting attorney general during some fairly interesting times, and we've heard a lot about that today. But I also want to commend the Department of Justice, the FBI, the White House, and all other law enforcement who was involved in the First Step Act. This is a tremendous shift, not just for the Department of Justice, not just for Republicans, and not just for Democrats. And it's the way government's supposed to work. It's supposed to show redemption, tough on traffickers, organized crime, and also work towards a smarter way to deliver criminal justice, particularly with addiction-related crimes. So my only hope is that because it is called the First Step Act, there will be a second step, And if you ever, unfortunately, I have some other questions for you. So anytime on your way out, if you have any advice on something Congress can do to continue this momentum, I would be very, very appreciative.
Well, Congressman, I was involved on behalf of the Department of Justice in the First Step Act, and I just want to commend everyone on this committee that worked on the First Step Act to successfully get that passed and to get it through both the House and the Senate. I actually know how difficult that is. I think one of the things that we could use your help on is to make sure you fund the First Step Act and what you've requested the Department of Justice to do. We continue to implement the First Step Act consistent with the law that you passed. And in fact, just last night, we sent out guidance to our U.S. Attorney's offices out of how to implement the First Step Act. And I know that the Bureau of Prisons as well is implementing the act.
And I would hope to work towards having a federal level pretrial release program to be available to every state and county courthouse across the country. Because one of the great ironies I've always found about your pretrial release program is it is incredibly effective, and then you get a 10-year minimum mandatory. So the pretrial release program at the Department of Justice and U.S. Attorney's offices across this country is phenomenal, and they deserve to be credited for that.
And as a former United States attorney for 5.5 years in Des Moines, Iowa, I understand uniquely how pretrial release works. And so we'd be interested in your proposal, and we'll look at that and work with you carefully to try to implement something like that.
Now, in our role as oversight, I do actually have a question about something that has come up in the past, and that, given the nature of the testimony today, very, very possibly could come up in the future. And I think often when we have names like Clinton and Comey and Rosenstein and Trump and Mueller and Russia, we forget that the law is the law. You testified earlier to Representative Jordan that we prosecute crimes, not people. And I think often across this country, we think laws apply differently to people depending on their status. And one of the areas where this came up, and it was something that concerned me before I was involved in this, is when we started talking about the difference between gross negligence and intent. And it was in a very particular statute, and we were dealing with it, and there were members of the FBI and the DOJ that said that were concerned about vagueness. But as far as I understand in the federal code, particularly the federal criminal code, gross negligence has the same definition approximately everywhere in the criminal code, right?
In my experience, your statement is generally correct, yes.
So if gross negligence would be vague under one particular statute of the criminal code, then we should be concerned that it's vague under every other other section of the criminal code.
That is correct. And there's, for example, jury instructions that would say, inform a jury as to how to evaluate a gross negligence standard to convict someone of a crime.
And assuming that it wasn't political in nature as to why gross negligence wasn't looked forward in any particular case, under your leadership, under the DOJ, has anybody reviewed this, looked at it, and made any proposals to Congress, particularly regarding whether or not we need to tighten up gross negligence language, not just, let's say, in the Espionage Act, but in any section of the federal criminal code?
As I sit here right now, I don't know the answer to your question, but I'd be happy to get back to you on that.
I'd appreciate that. And then I'm just, again, under normal course of order, I'm assuming it works the same as everywhere. Law enforcement agents, and I know a lot of FBI agents actually do have law degrees, but FBI agents investigate crimes, and then it goes up the food chain to the U.S. Attorney's office, usually, maybe.
And remember, I mean, you need a predication to even open an investigation, and that's the step that I think a lot of people forget. I mean, there's many steps along the way, and when you conduct a criminal investigation, first you have to predicate the investigation. Then it's investigated by the special agents that investigate the crimes. Typically, an AUSA works with them to get search warrants and the like, and then ultimately a case is developed and presented to a grand jury, and that is charged. So I mean, that's typical. And then again, there's a discovery process and a trial process. It's a very, very well worn, and to go back to something you mentioned earlier, Congressman. All of that is done at the Department of Justice without improper interference or interference based on a political nature.
Well, I'm just concerned moving forward that we have the same, I mean, everybody knows, and obviously this is hypertension and hyper-political, but I'm very concerned moving forward that everybody knows what the rules of the game are as far as statutes are, and that the law is actually applied in the way the law should be applied, because I do believe in the past it has not been. And obviously this is continuing to go on. This hearing today is noticeable of that. So on your way out, maybe it's the best time to deal with some of those things, because sometimes that's when we have the courage to do it. But this could very much come up again in the future.
Thank you, Congressman.
Time of the gentleman has expired. The committee will stand in recess for 2 minutes. I ask that the members remain here if they can.
All right, as we are awaiting a little more drama, we've been seeing some here as I bring my experts back in to discuss this testimony of Matt Whitaker. What did you think? What really stood out to you, Pam?
What stood out to me was the line of questioning about SDNY and whether the president lashed out at Whitaker. Whitaker said that no, that he didn't. But of course, our reporting is that the president did, in fact, vent to him. The sources described to us as lashed out to him about.
And literally described to you and to Laura Jarrett.
This
was your story in December.
My colleague Laura Jarrett and I did the story in December that the president was unhappy about the charges against Michael Cohen because the president was implicated in it, this hush money scheme, as individual one of the court documents. And so the president brought it up to Matt Whitaker on 2 occasions, also on Cohen lying to Congress. But the congressman stopped short of asking him, did the president ever bring up the SDNY investigation to you or Michael Cohen? The congressman stopped short of that, and that would have been a significant line of questioning because Matt Whitaker had denied ever talking about the Mueller probe to the president. But according to our reporting, he can't deny the SDNY probe because he did have those conversations. Exactly. So he never actually denied it because it wasn't asked specifically.
Eric Columbus, you're a former DOJ official. The idea that the acting attorney general might deny that just based on the characterization of lashing out, although we're assuming that the president was at least animated. We know that he was animated from Pam and Laura's reporting. What would that tell you if the acting attorney general is trying to find some wiggle room just by around that term lashing out?
Well, I think he's very eager not to do anything that will sell out the president, because his future career may depend on that. Yet at the same time, he doesn't want to trample on the Mueller investigation because he may believe in it in some level, and also doesn't want to have that legacy in the way that many former Nixon aides did. So he's trying to be very careful and walk a thread and needle here, and that's his main goal, just to run out the clock by doing that.
You know, he doesn't want to dump on Rosenstein on the way out the door, and there are some Republicans who can't stand Rosenstein, and he wouldn't do that either. He wouldn't take on Mueller specifically. I mean, Eric Swalwell tried to get him to take him on, and he wouldn't. And he said he agreed that he was honest and that he was not conflicted and that he had his respect. Although he wouldn't say the sentence that the congressman wanted him to say for the convenient soundbite. So he's kind of walking this line because Republicans don't like Mueller, don't like Rod Rosenstein, but he, for now, runs the Justice Department.
He does. And remember the whole premise for Democrats of bringing Whitaker before their committee in the first place. When they won the majority, they said that they wanted him to come in order to ask basic questions about whether he's messing with the Mueller probe, since he was put in charge without being, confirmed, with being somebody who has publicly stated opposition to the Mueller probe. And on some really basic questions that he did answer, his answer was effectively no. So on that, we did get some answers. On a lot more, we did not.
All right, I am going to hand over the reins here to Brooke Baldwin as she continues our special coverage of the Matt Whitaker testimony before Congress. Brooke?
Hey, Bree, thank you so much. Hi, everyone. I'm Brooke Baldwin. It's Friday. I have lost count of how many hours we're into this Matt Whitaker. He's the acting AG. He's been testifying in front of the members of the House Judiciary Committee. You've been listening to all kinds of, discussions over what he has said, what he hasn't said, citing executive privilege during certain occasions. But let's just, in case you have not been glued to the television, as we all have for the last several hours, let's just reset for all of you here at the top of the hour and go to our senior congressional correspondent, Manu Raju, who is up on Capitol Hill, obviously watching this whole thing. And I'm curious, what are you hearing from lawmakers on this?
Well, the one thing that Whitaker has tried to make clear in this hearing, where there's been not much clarity, was that he did not speak to the president about the special counsel's investigation. That was what he tried to make clear early on, that was not a part of his discussions. But there are also questions about his decision not to recuse himself over the investigation, because he said that it was his own personal decision that is fine for him to continue overseeing this investigation despite the views of ethics officials. And it sounds like, Brooke, that it may be coming back to the hearing.
Yeah, let's go back.
You haven't taken any sort of a loyalty to Donald Trump.
No, I have not taken this role.
Have you signed any non-disclosure agreement with the White House or Donald Trump?
We signed our ethics pledge, which was the most robust ethics pledge, but I haven't signed any other documents other than the normal DOJ employment document.
And there was no non-disclosure agreement with anything you signed, correct?
I don't believe so, but I don't know what the standard DOJ forms are.
In fact, the only thing you really had to do before you could assume your current position was take an oath to the United States Constitution, isn't that right?
I proudly took the oath for the second time when I came back to the Department of Justice.
Thank you. So I'm going to ask you a series of questions about the U.S. Constitution that you can easily answer yes or no. The first question is, there is no sentence in the Constitution that states that the President's National Security Advisor can't be indicted, correct?
Congressman, as is consistent with the practice of the Department of Justice, we investigate crimes and we prosecute individuals that commit crimes.
Just asking a simple question. I'll go on. There's no sentence in the U.S. Constitution that states the President's former campaign chairman can't be indicted, correct?
Same answer to your previous question.
Does that sentence exist in the Constitution?
Of course it does not, Congressman.
That's
you know
right,
that, and I know that.
Right, because Paul Manafort was indicted. There is no sentence in the Constitution that says the President's children can't be indicted, correct?
Congressman, you can give me the whole list. I mean, sort of.
No, I'll give you three more.
Okay.
Yeah, right?
There is
Children's
no
not in there,
sentence
right?
in the United States Constitution that says that the President's children cannot be indicted.
There's no sentence in the U.S. Constitution that says the Vice President can't be indicted, correct?
That's correct.
Right. There's no sentence in the U.S. Constitution, this is my last one, there's no sentence in the U.S. Constitution that says the sitting President of the United States cannot be indicted, correct?
Congressman, because that is the opinion of the Office of
Yeah, I
Legal
don't
Counsel
actually
of the
care
Department
what
of Justice.
DOJ policy is. I'm asking about the
Consistent with the
Constitution.
practices of the Department
Mr.
of
Whitaker,
Justice
it's just a
for
yes or no question.
years,
Mr. Whitaker, I'm asking you a
under
factual.
both administrations.
After this hearing, you can spin the Constitution all you want. As you sit here today,
not
you just
spinning the
have to answer a factual yes or no question. I'm going to make it even easier for you. There's no sentence in the Constitution that says, quote, the sitting President of the United States cannot be indicted, unquote. Correct?
Congressman,
yes or no?
As you know, I would
have
refer
it
you.
right here.
I have a copy myself.
Right, so is that sentence in this Constitution? It's not, correct? I'm not trying to trick you. It's not a hard question.
I don't, again.
It's a founding document of our federal government. Is that sentence in this Constitution?
Congressman, you and I both know that the way that the OLC opinion is written.
I'm asking about the
lays out a
Constitution,
very
the
clear
founding.
question as to why the President of the United States.
I'm just asking about the Constitution.
Sitting President of the United States can't be indicted.
I'm just going to, Mr. Chair, I'm just going to submit the U.S. Constitution for the record and say, no, that sentence is not in there. Now we're going to move on. Earlier today, you had testified that you did not communicate to Donald Trump or senior White House advisors about the special counsel's investigation. So I'm going to ask you a related question. Did you communicate to Donald Trump or any senior White House advisors about investigations from the Southern District of New York concerning the Trump Organization, the Trump Inaugural Committee, Michael Cohen, or other investigations that relate to Trump entities or potentially the president?
Congressman, I mentioned that. I said other investigations in my opening statement. I really don't have anything further to add to that answer.
And when you said other investigations, you mean you communicated to the president about other investigations?
No, I didn't. That's not what I said in my opening statement. I'll refer you back to my opening statement. I was very clear.
Did you communicate to the president, any senior White House advisors about investigations from the Southern District of New York related to Trump entities?
Again, I was very explicit in my opening statement as to that, not only about my communications regarding the special counsel's office, and I said other investigations, and the Southern District of New York would be included in other investigations.
Okay, thank you. So we're going to move to another subject. The president has talked about national emergency. Under the latest FBI data, it's correct, isn't it, that violent crime across the United States has gone down?
Yeah, we celebrate actually that violent crime has gone down over the last 2 years.
Property crime has gone down as well, isn't that right?
Congressman, as I sit here right now, I believe generally all crime is down over the last 2 years.
And then my last
since
question.
Trump was elected.
Sure. My last question to you is, you would agree with Donald Trump, wouldn't you, when last year he tweeted out that border crossings are at a 45-year low?
We saw a precipitous decline in border crossings after the president was elected and sworn into office. Unfortunately, we haven't been able to retain those gains, and we've seen an absolute dramatic surge in family units.
Thank you.
Time of the gentleman has expired. Mr. Raskin.
Mr. Whitaker, before you took the call from President Trump, you had a fascinating career. Owned a daycare center, a concrete supply business, trailer sales, GOP activist, U.S. attorney who unsuccessfully prosecuted Iowa's first openly gay state legislator on trumped-up Hobbs Act charges that were dismissed by the jury in about an hour, Senate candidate. There have been some scandals, too. Here's one. Trump's acting attorney general involved in firm that scammed veterans out of life savings. Veteran says, "I spent the money on a dream. I lost everything." But the newspapers say you struck gold when you arrived in Washington, which the president calls the swamp. Here's one that tells the story. Conservative nonprofit with obscure roots and undisclosed funders paid Matthew Whitaker $1.2 million. According to the Washington Post, in the 3 years after he arrived in Washington, Whitaker received more than $1.2 million as the leader of a charity that reported having no other employees. That's a pretty good deal. Now, what was the name of the charity that you ran, Mr. Whitaker?
Congressman, you've mentioned a lot in your...
No, but I'm asking you a very specific question. What was the name of the charity?
You have challenged my character.
No, I'm asking you a question. I control this time, Mr. Whitaker. If you want to ask the chairman for time of your own, you can do it. This is my time. Mr. Whitaker, you don't run this committee. You don't run the Congress of the United States, and you don't run the Judiciary Committee.
Gentleman will suspend. The gentleman is correct. The witness will answer the questions, and it's up to the gentleman to decide what questions. The gentleman will continue. We'll resume.
What was the title of the not-for-profit that you ran?
What time period, sir?
What was the last title? I know it changed its name 3 different times, right? What was the final name?
While I was employed as the executive director, it was called the Foundation for Accountability and Civic Trust.
Did you name it?
I did. Actually, you know...
Those are highly noble goals, accountability and civic trust. So let's talk about some accountability and civic trust. Mr. Whitaker, I've got a question for you.
No, you asked me a question.
I asked you a question. I control the floor, Mr. Whitaker. You don't understand. Now,
Gentleman is correct. The gentleman controls the time, and if he wishes, as many members have done on occasion, they make a statement, they don't even ask a question, but if he wishes to proceed to another question, it's his time.
But Congressman, I do not feel, Mr. Chairman, I do not feel like my answer would be complete on the record.
It's up to
the question he asked.
okay, Mr. Whitaker, see if you can get into this. Tell us where the money came from that you were paid, the $1.2 million that you were paid before you went to the Department of Justice. I'm asking my question.
Mr. Chairman, point of order, which overrules your question. Point of order.
The gentleman will explain his point. The gentleman will suspend. The gentleman will state his point of order.
Look, we're going to go down this probably many more times, but again, if you wanted to do a confirmation hearing, this is not under the scope of this hearing. This is not a confirmation hearing and is not shown to be a...
Mr. Chairman, this goes to
the gentleman's point of order is not well taken. The gentleman, the gentleman from Maryland has the discretion to ask the questions. The gentleman will proceed.
Appeal the ruling of the chair.
The gentleman has appealed the ruling of the chair. The gentlelady has moved to table. All in favor of the motion to table the appeal of the ruling of the chair will vote aye. Aye. Opposed, nay.
Aye.
The ayes have it. The ruling of the motion is tabled.
Mr. Chairman, can you and I engage in a colloquy?
Gentleman will.
Can we suspend the clock and you and I engage in a colloquy?
We're in the middle of the
Point of order, Mr. Chairman. Is the ranking member just going to continue to interrupt when he doesn't like the flow of questions?
Excuse me.
I'll probably make a point of order when that needs to be made. Right now,
good if it'd be useful if it was actually a point of order.
Everyone will please suspend. The gentleman made a point of order. It was ruled out of order. Right now, the gentleman has the time. If the ranking member wants to make a point, I'll recognize him after the gentleman is completed. The gentleman will resume.
Thank you, Mr. Chairman. It's been reported publicly that there was one donor. And as we understand it, I think you're testifying today that you were the sole employee of the group. So there was one donor and one employee. Do you know who the donor was to the group that funded your salary for $1.3 million?
Yes, I do.
Who was the donor?
The donor was another nonprofit 501c3 organization called the Donors Trust.
Okay, now that was the pass-through vehicle, but who reached into their pocket and wrote the check to go through that to pay your salary?
Congressman, as you know, because you've looked at this issue, the Donors Trust is much bigger than the Foundation for Accountability and Civic Trust and raises millions, if not hundreds of millions of dollars every year. I actually, as I sit here today, have no idea who the donors to Donors Trust that then funded
thank you.
the foundation.
All right, well then I've got a theory that I want to float with you, and it goes to something very strange that's been happening at the Department of Justice recently. A casino billionaire and magnate Sheldon Adelson hates online gambling for obvious reasons. It's competition for him. He wants people in the casinos, not online. And he spent more than $1 million lobbying Congress to override a 2000 opinion by the Office of Legal Counsel at DOJ, saying that the Wire Act plainly prohibits only sports gambling online, not gambling in the states, which is why Florida, Pennsylvania, New Jersey, lots of states have built important businesses for themselves online. But Congress wouldn't change the law according to the demands of Mr. Adelson. So rather than change the law, he decided to try to get the Department of Justice to change the interpretation of the law. And he threw millions into a campaign to remake the DOJ and get the Office of Legal Counsel to perform a complete reversal and say that the Wire Act bans the kinds of lotteries that states run online, even though its language plainly prohibits only sports betting. And when Donald Trump won and Mr. Sessions became AG and you became Chief of Staff, DOJ leadership ordered a reevaluation of this legal question. And what do you know? The Office of Legal Counsel found some subtle and invisible points of law that apparently escaped the Department of Justice back in 2011, and it reversed the plain reading of the interpretation, which talks specifically about sports betting. Now, were you involved in that decision?
Congressman, the General Sessions was recused at the time that decision came out.
So were you recused too?
I was recused, and so I was not involved in that decision.
Did you ever talk to Sheldon Adelson about it?
No, I've actually never met Sheldon Adelson.
Okay, did you talk to any of his lobbyists about it?
No, I did
Did
not.
you talk to Charles Cooper about it?
No, but I do know Charles Cooper, and I would point out one of the things, Mr. Rath.
Well, look, if you can ask the chairman for time, but I can't give you my time. Forgive me, we only have 5 minutes.
OLC opinion came out.
The gentleman controls the time. At the conclusion of his statement,
Is the chairman not wanting the witness to get full answers?
at the conclusion of his 5 minutes, I will afford the witness some time, but the gentleman controls the time.
Thank you, Mr. Chairman. In January and February of 2018, the chairman and vice chairman of Wild Rose Casino and Resorts, a casino in Iowa, each donated $2,600 to your Senate campaign, which was over 4 years before when you lost that campaign. How did these casino operators come to donate to your campaign several years after you lost? Did you talk to them?
Time of the gentleman has expired. The witness may answer the question.
To answer your question specifically, no, I did not. To go back to the other point I'd like to make, Congressman, is that the first OLC opinion that preceded the one we just issued in November was done, and the state of Illinois provided a white paper regarding the position on the Wire Act. And so I think it is very consistent, and your inference that somehow that process was corrupted or corrupt is absolutely